Thank you, Igor. Thank you, Susanna, for this. Dear colleagues, good afternoon. Part of International Maritime and Transport Law course are sessions about maritime and transport law. Just briefly, I will refer to the last event, same event, when I was talking about content of the Bareboat Charter in national and autonomous legal sources in this same classroom, and I decided this time to continue this with the same subject. So I thought, why not to speak about Bareboat Charter again? So this year I chose one detail from the content of the standard forms of bareboat charter contracts, and that is insurance risks. So the purpose actually of this presentation is to determine the main features of bareboat charter contract and explain the insurance interest of the contracting parties during bareboat charter, and finally to analyze the insurance provisions from the standard forms of bareboat charter. So I wanted to, with this presentation, I would like to highlight that it's important to understand the existence of insurance interests of both contracting parties and the owner and the bareboat charterer during a bareboat charter period. And also, I would like to highlight that insurance interests of both contracting parties during bareboat charter should not be left to chance, and that insurance of the risks should be resolved without a doubt in bareboat charter contract. So in this presentation, I would like to determine the main features of bareboat charter and explain insurance interests of the contracting parties during bareboat charter. And after that, I will point out some characteristics of hull and machinery insurance, then insurance against war risks, and liability insurance or protection and indemnity insurance during the bareboat charter contract. And also we will see in which way this issue of insurance is prescribed in content of BIMCO's standard bareboat charter form. Its code name is BERCON 2017, as you can see. And at the end, I will summarize the above. So provisions of insurance, mainly hull and machinery insurance and insurance against war risks, and liability insurance or protection and indemnity insurance for duration of bareboat charter are particularly important. Why? Because it's necessary that the parties and owner and the charterer know that insurance provision or insurance under title insurance should be part of the bareboat charter contract. So stating from the fact that in modern business practice of shipping contracts, also as well as in the business practice of bareboat charter, standard contract forms are used. The question is in which way this issue of insurance is dealt with the content of standard contract forms. So we can find provision under title insurance in this standard bareboat charter party with the code name BERCON 2017. This is the last bareboat charter standard contract form by BIMCO, and it is internationally accepted standard contract form that is used in the contracting of bareboat charter. So BERCON 2017 contains so many provisions, and the clause 17 is entitled insurance, and this clause consists of three sub clauses. First one is general, the title of that one is general. Then the next one is charterers to insure, and the last sub-clause is owners to insure. There is a plural. So, of course, I will analyze the content of this clause 17 of the BIMCO's BERCON 2017. But before that, let's see some main features of the bareboat charter. So the bareboat charter contract is completely different from other charter contracts such as time or voyage charter. It's different because of its legal nature. This type of contract differs actually in few criteria, such as, first of all, the aim of the conclusion of bareboat charter. So maybe bareboat charter may appear to be simple contract. So we have the owner on the one side, and the owner gives to the bareboat charterer a vessel for the performance of seagoing activities, and bareboat charter on the other side pays the hire to the owner in consideration of performance of that activity. So there is a question, what can be complicated about that? That this is very complex contract can be seen in the complex systems of the parties' legal relations stemming out of the provisions of the vessel for use. So there are two important facts about bareboat charter. First one is that by conclusion of contract, the owner gives the vessel for use to the bareboat charterer, or we can say that he delivers the vessel into possession, so the bareboat charterer can use it as agreed. Because of that, bareboat charter becomes the ship operator, or as we can see in some legal literature, some authors call him maritime owner. So taking into consideration all these really basic characteristics of bareboat charter, alongside the owner, and the bareboat charterer also has a legal interest in hull and machinery insurance and insurance against war risks and liability insurance or protection and indemnity insurance in the duration of bareboat charter contracts. A bareboat charterer can also suffer damage arising from the loss or damage of the vessels, so his interest is completely justified. So the basis of the bareboat charterer interest is his obligation to maintain the vessel during the bareboat charter contract and return it in the same condition in which it was received after the expiration of the contract. So because of these characteristics, we can say that the bareboat charter is a type of the contract in which there is a wider circle of the person on the side of the vessel who can be holders of insurance interests from vessel use. So, and the owner and the bareboat charterer have definitely an interest in obtaining insurance against hull and machinery, insurance against war risks, and protection and indemnity insurance. So these types of insurance, I can say that they are particularly important types of insurance, and from the side of bareboat charter contract. So the first type of insurance try to prevent a loss or damage to the vessel, and other type of the contract can of insurance try to protect the interest of the owner and the bareboat charterer when, due to possible liability, they are obliged to indemnify damage. Also, I have to highlight one more thing, and that is how the parties' insurance interests coincide. It is also possible for the parties to leave some interest unsecured. Therefore, it is necessary to establish with certainty whose responsibility is to insure hull and machinery, insurance against war risk, and oneself against all liabilities, with the purpose of protecting its interests during bareboat charter contract. Of course, there are several possible sources of a liability, such as contractual, third-party liability, and liability towards one's own crew. For example, the owner's contractual liability can refer to his liability for the vessel's navigational incapacity, and the bareboat charterer's contractual liability may concern returning the vessel to the owner in the condition received for the charter, taking, of course, into account regular wear and tear of the vessel. While third-party liability, of course, refers to the collision or maritime pollution and so on. So in this case, the aggrieved party is, of course, third party. And the special type of liability is obligation to the crew. For example, we can talk about liability for damage occurred due to physical injury or death of crew member, or liability for damage caused to items for personal use by a crew member, or about obligation to cover the costs of repatriation, return trip back home on board for crew member, and obligation to pay salary or salaries in the event of shipwreck. So in the context of liability, of course, it is also important to determine the provisions of compulsory insurance stipulated by few international maritime conventions. So we have owner as a party in bareboat charter contract. So even so he is a party in bareboat charter contract, and even he gives his vessel to bareboat charter to use, letting the vessel to be used by the bareboat charterer not relieve the owner of liability. So the provisions of concerning compulsory insurance are especially important, and from the position of bareboat charter contract, since the owner has to be aware of these obligations regardless of giving the vessel to the bareboat charterer for use. So the example of owner's liability we can find, first of all, in CLC and bunker convention. So CLC convention directs the liability for use for sea pollution by oil to the owner, and also according to the bunker convention, this one also directs the liability for sea pollution by bunker oil to the owner and also to the bareboat charterer. And also some provision solutions of compulsory insurance we can also find in other conventions. But first of all, let's see these provisions from CLC and bunker convention. So according to CLC, a vessel that carries more than 2,000 tons of oil in bulk as cargo must have compulsory insurance or other financial security. And according to bunker convention, the owner of any vessel having a gross tonnage greater than 1,000 is obliged to maintain insurance or other financial security for the damage due to sea pollution by oil, bunker oil. Some provisions of compulsory insurance we can also find, for example, in wreck removal convention and in Athens convention and so on. But from the position of bareboat charter, it's important that letting go of a vessel to be used by the bareboat charterer does not relieve the owner of liability, as we could see from this international convention. So provision under title insurance we can find in standard contract form, BIMCO standard contract form, BERCON 2017. So this one we used as an example of bareboat charter contract. This contract form contains many provisions which are used for regulations of parties' rights and obligations. So according to this form, the bareboat charterer generally pays and for fuel and for crew. So all operating expenses, including maintenance, repair, and also insurance. So if the parties so agreed. So this provision it contains 3 sub-clauses, but it's important that sub-clause B and C are alternatives, and their application is agreed by the parties in the first part of the standard contract forms. So according to this provision, this clause, sub-clause actually A, the party insuring the vessel shall do so on such terms and conditions and with such insurance as the other party shall approve in writing. So also party insuring the vessel shall name the other party as co-assured. So according to this provision, the other party must agree with the choice of insurer. According to another subclause from this same contract form, during the charter period, the vessel shall be kept insured by the charterers at their expense against hull and machinery, war and protection and indemnity risks, and other risks against which it is compulsory to insure for the operation of the vessel. According to this one, also such insurance shall be arranged by the charterers to protect the interest of the owner and the charterer. So we can say that this provision definitely protects and the interest of owner and the interest of bareboat charter, so both parties. Also, according to another subclause, during the charter period, the vessel shall be kept insured by the owners on their expenses against hull and machinery and war risks. So in this case, we just have hull and machinery and war risks, but during the charter period, according to this provision, the vessel shall be kept insured by the charterers on their expense against protection and indemnity risks. So, and any, of course, other risks against which it is compulsory to insure for the operation of the vessel. So these provisions B and C are, as I said, alternatives, and their application is agreed by the parties in the first part of the contract form. But it's interesting that in this case, charterer is it is charterer obligation to pay protection and indemnity risks. So any discussion of the insurance in bareboat charter contract is impossible. It is impossible to present without an overview of main features of bareboat charter contract. So we emphasize that both parties and the owner and the bareboat charter have an interest in insuring and hull and machinery and insurance against war risks and protection and indemnity insurance during charter period. And we also saw that, and we point out that the owner can be liable for damage caused by the vessel and when he is party in bareboat charter contract. Also, from the example of the provisions of BERCON 2017 form, we have determined that the expense of hull and machinery, insurance, and also war risks can be borne by the charterer according to subclause 70B, or by the owner according to clause 17C, depending on which contractual provisions of the form the parties have agreed upon. And in both cases, bareboat charterer pays the costs of P&I protection and indemnity insurance and any risks against which it is compulsory to insure for the operation of the vessel. So whatever the parties have agreed, the goal, of course, is to protect their interest, and that is the goal of the insurance in general. Thank you.